Hi guys, this is Ayantika, your legal faculty here at CLATapult, and in today's video we are going to understand one of the rarest and exceptional remedies in Indian constitutional law, that is the curative petition. This is not an ordinary concept. Even the Supreme Court describes this as the remedy of last resort. It comes into play only when everything else has failed and yet justice still seems to be in danger. Before we move into the substance of today's topic, let me give you a quick update for the ones who are preparing for law entrance exams that our institute's batches for CLAT 2027 and CLAT 2028 have already started. If you are looking for structured guidance, detailed conceptual training, and consistent mentorship, you can find all information related to the course, schedule, and batches mentioned in the website given on the screen below. If you have any further questions or need personalized guidance, feel free to reach out on the contact number given in the screen below. Now coming back to today's topic, to understand why curative petition exists, we need to first understand how finality works in Indian judicial system. The Supreme Court of India is the highest court in the country, and once it delivers its judgment, the matter ordinarily comes to an end. Against a Supreme Court judgment, the Constitution provides only one remedy, that is, a review petition under Article 137 of our Indian Constitution. Once the review petition is dismissed, the general rule is that the case is finally closed. However, the Supreme Court itself recognizes an important reality, that judges are human and human error is always possible. There may be situations where a judgment leads to a grave miscarriage of justice, and yet no legal remedy is available. Completely shutting down the doors in such cases would mean allowing injustice to survive merely in the name of procedural finality. It was this concern that finally led the courts to create an extraordinary remedy through judicial innovation. The concept of curative petition was laid down in the case of Rupa Ashok Hurra versus Ashok Hurra in 2002. In this case, the Supreme Court held that to prevent abuse of its process and to cure gross miscarriage of justice, it could reconsider its own final judgment even after the dismissal of review petition. The court clarified that a curative petition is not found in the Constitution or any other statute. It is a judicially evolved remedy derived from the inherent powers of the Supreme Court. A curative petition is filed only after two stages have been crossed. First, the final judgment of the Supreme Court, and second, the dismissal of review petition. It allows the Supreme Court to review its own final decision but only in exceptional circumstances. That is why this is often described as the last hope. The Supreme Court has laid down very strict guidelines or conditions for entertaining a curative petition. It can only be considered when there is violation of natural justice, such as when a party was not given a fair hearing or when a judge failed to disclose conflict of interest. Additionally, the judgment must result in gross miscarriage of justice. A curative petition is not meant to re-argue a case or re-evaluate the evidence or correct minor legal errors. Mere dissatisfaction with the outcome is never enough. Because of its extraordinary nature, the procedure for filing a curative petition is deliberately made stricter. It must be certified by a senior advocate stating that it satisfies the conditions laid down by the court. The petition is then circulated to the three senior-most judges of the Supreme Court along with the judges who delivered the judgment originally. In most cases, the matter is decided in chambers without an oral argument, and only in rare situations the court allows an open hearing. Although there is no strict provision for curative petition, the legal basis is traced to Article 137 of the Constitution, which grants the power to review, and Article 142 of the Constitution, which empowers the court to do complete justice, and the inherent power of Supreme Court. Together, these powers enable the court to step in when justice would otherwise fail. Curative petitions have been filed on several high-profile cases over the years. In the case of Nirbhaya, curative petitions were filed by the convicts which were dismissed. Similar petitions are seen in death penalty or mercy cases. Even in Ayodhya dispute, curative petitions were filed and dismissed. These examples show that even though remedy exists, the success rate is very low. The Supreme Court has repeatedly stated that finality of judgments is essential for legal certainty and public confidence. Endless litigation undermines the authority of judiciary. Therefore, curative petitions are entertained only when justice itself is at stake, not when the party simply wants another chance to argue. To conclude, curative petition is the judiciary's self-correcting mechanism. It reflects a careful balance between the need for finality and the need for fairness. While the Supreme Court is the final authority under the Constitution, it has also acknowledged that it is not infallible. Thank you and see you in the next video.